Greetings, law fans. This is attorney Jeffrey Howard, and I'm presenting you with Legaleze 101, episode 7. This one is about the definition of injury by accident. That's a phrase, not just a word here, so we're getting crazy. And this phrase is particularly important in regards to North Carolina workers' compensation law. Why is it important, Jeff? Well, I'm so glad you asked. Most people think that any injury at work would give them workers' compensation benefits in North Carolina, maybe in the other states, but I can't speak to other states. I can't speak about North Carolina workers' comp though. But that is absolutely incorrect. Any injury at work doesn't necessarily create a workers' compensation claim. You have to have what is defined by our law as an injury by accident. That's the last time I'll use these little funny finger quotes, I promise. There are other elements to having a compensable workers' compensation claim, but those will be covered in other videos, I hope. But for now, we're just going to focus on injury by accident, which is one of the elements of a compensable workers' compensation claim in North Carolina. By the way, I'll be relying a lot on the work done by Lynn Jernigan in his great horn book on this subject. So thanks to Mr. Jernigan for that. An accident is a definite event which can be fixed by time and place. Case law has mentioned that as sort of a definition as an accident. So a definite event which can be fixed by time and place. It's not something that gradually develops, like say an occupational disease, which is also compensable, but that's a different thing. It's something that happens, boom, right there, and you can say when it happened. It also has to occur when the work routine has been interrupted or unusual conditions are created which are likely to produce unexpected consequences. In essence, it's not the usualness that's important, but the unexpectedness that's important to define what's an injury by accident. Sort of the landmark case in this is called Swindell versus Davis Boat Works Incorporated. Essentially what they said is that normal work, even if it's strenuous, doesn't equate to an accident. The example in this case was a guy was working on sort of a crowded work area floor. He sidestepped another worker and felt something in his knee pop. Well, the court said that he had sidestepped 1,000 times in his work and his normal routine. That wasn't an accident. It's just something he was doing, and he had an injury. That's not an injury by accident. There was no disruption in his work routine. There's nothing unusual about what he was doing there. So that wasn't deemed compensable. Unusual conditions help, of course. There's another case, Gaddy versus Cranston Printworks Company, and the employee was injured doing the routine job of another employee, but it wasn't his job. It was a routine job of another employee, but it wasn't his job. That was deemed to have disrupted his routine enough so that they defined that as an injury by accident. It was not his job, so it was compensable because it was unusual and unexpected, because he wasn't doing his own job, he was doing someone else's. So it sort of makes sense. I had an interesting case several years ago where this defense came up, and there wasn't an injury by accident. My guy was, in the course of his work, running up some stairs to deliver a package. As he was running up these stairs, he felt something in his knee pop. Well, this is very similar to that Swindell versus Davis Boat Works case. There's an argument that that wasn't an accident. He was just going upstairs, just like he'd be going upstairs at the gym or at home or at the mall or wherever they have stairs. So there wasn't anything unusual, no unexpectedness, no break in his work routine. Now, I think in a different example, let's say my guy was running up the stairs and the stair gave way. The stair itself broke. Well, that's unusual. I think that's a disruption. That's unexpected. I think that would be defined an injury by accident, but just running up the stairs, feeling something in your knee go, that's not an accident. Clients are often blindsided by this technicality, and so they're pretty surprised when it's brought up as a defense by the insurance company. Just remember, workers' comp doesn't cover everything that happens at work. It just doesn't. So when you're reporting your claim, if you're doing it on your own, it is very important that you make sure the incident is described as an accident, if in fact it is an accident. Now, to a certain degree, you can't help how the injury happens. You have to be honest about how it happens, but if there's a way that it can be characterized as an accident, it needs to be characterized as an accident. You want to make sure that the truth is let out. So, of course, there are exceptions to every rule. With back injuries, you no longer have to have an injury by accident under North Carolina law. You have to have what's called a specific traumatic incident. So as long as you know that it happens right then, sort of in that defined time and place, then you're okay. Hernias are pretty much the same thing with a specific traumatic incident. Intentional assaults, which are clearly not accidental, at work, as long as the dispute giving rise to the assault is work-related, those are compensable under North Carolina workers' compensation law. So, that can help. But that's enough for now. Thanks for joining me again. I hope you learned something useful. Remember, if you have an injury on the job in North Carolina and you're looking for legal advice, please call me, 919-929-2992 or 888-929-5241. Thanks again for joining me. Have a good one.